Mr President, I move this bill because it amends Section 4A of the Summary Offences Act 1988 to limit the scope of the offence of offensive language. Specifically, it narrows the offence to only apply where the offensive language is used in a hostile or threatening way. That is the key point, in a hostile or threatening way, in a significant way. This is a vital modernisation of the law and one that retains community protection while removing the risk of arbitrary, racist or discriminatory enforcement. The offence of offensive language as currently drafted is overly broad. It captures everyday expressions used by Australians in frustration, grief, protest and sometimes humour. But this law has never been about decency, it's been about discretion. And too often that discretion has been exercised at the expense of marginalised communities. In 2023, there were 564 offensive language charges finalised in New South Wales courts. Shockingly, 45% of those charges were laid against Aboriginal and Torres Strait Islander people, who make up just 3.4% of our state's population. This is not justice, it is systemic bias codified in law. This amendment will prevent the use of Section 4A as a blunt instrument, Mr President. It ensures that only genuinely threatening or hostile conduct and language can be prosecuted. Swearing at the air, venting frustration, or even protesting with strong language will no longer be grounds for a criminal record. The Royal Commission into Aboriginal Deaths in Custody recommended more than 3 decades ago that minor public order offences like offensive language should not be used to justify arrests. Yet today, these laws continue to funnel Aboriginal people and people from lower socioeconomic backgrounds into the criminal justice system for conduct that presents no actual harm. Courts have long recognised the fraught nature of this offence. Historically, these laws were never about protecting public order. They were about control, Mr President. Offensive language offences can be traced back to colonial statutes introduced to discipline and suppress the convict population. These early laws were tools of authority designed to enforce moral codes and submission through punitive measures. That legacy has endured. What began as a means of controlling convicts has evolved into a mechanism that disproportionately targets those already over-policed and marginalised, particularly Aboriginal Australians. In Polly versus Constable Brown 2002 126A Crim R316, the court held that the words "fuck off" used by citizens towards police were not legally offensive in context. Justice Smart rightly noted that courts must reflect modern community standards where such language, while coarse, is not exceptional. Likewise, in Stutzel versus Reid in 1990-20 New South Wales LR 661, the Supreme Court found that offensive language can constitute an offence even when no one is present at a public space to hear it. Even when no one is present in a public space to hear it. In that case, an Aboriginal man yelled from a private yard at 2 police officers saying, "Why don't you fuck off, you dog-ass cunts?" The charge was upheld, not because anyone in the street heard it, but because someone could have heard it. Justice Loveday, he probably was yelling at you, Justice Loveday confirmed that actual harm or public disruption is not required to satisfy the offence. This case starkly illustrates how the current law criminalises language in the absence of a victim, reinforcing how low the threshold truly is. Leading criminal law scholars from the UTS Law Faculty to the authors of criminal laws materials and commentary have consistently called for reform of Section 4A. Joe Lennon, writing in the Current Issues in Criminal Justice Journal 2007, described offensive language laws as having a, and I quote, Janus face, appearing to protect public civility on one side while enabling discriminatory and inconsistent enforcement on the other. She observed that the ambiguity of what counts as offensive has allowed police to disproportionately target Aboriginal Australians, embedding subjective bias into everyday policing. These laws, Lennon argues, do not reflect a community standard. They reflect a pattern of criminalising cultural expression and dissent. Reform is long overdue to ensure our legal system does not conflate cultural difference with disorder or frustration with threat. These voices affirm that the law disproportionately targets the poor, the young, and Aboriginal people. This bill answers that call. It retains the offence in a targeted form, preserving public safety and dignity while removing the pretext for arbitrary and discriminatory enforcement. It also removes any uncertainty for police. Only language that they deem to be threatening or hostile can now give rise to that charge. This is not a radical change. It is a modest, rational step forward. The law should not punish people for the words they use in frustration or protest. It should only intervene when those words are used as a weapon to intimidate or threaten others. This amendment strikes that balance. I commend the bill to the House.